I. Discussion of the working of the Ministry of Law and Justice. Dr. M Sudarsana Natchiappan to raise a discussion on the working of the Ministry of Law and Justice. Sri Natchiappan.
Thank you, Deputy Chairman, sir. I move the discussion on the working of the Ministry of Law and Justice, which is a very important ministry, and we are celebrating the 125th birth anniversary of Dr. Ambedkar, who is the architect of the Constitution of India. Sir, in this juncture, I would like to draw the attention of the government that present system of having 3 departments in the Ministry of Law and Justice, which are Department of Legislative Department, and then Department of Law, and then Department of Justice. But at the same time, we are not only ruled by rule of law of domestic law, but we are now ruled by the international law. Many of the conventions and many of the multilateral treaties are now binding the citizen of India. We are knowingly or unknowingly, the citizens are controlled by the international law. We can take multilateral treaties already submitted to the Secretary General of United Nations, covers a lot of the subjects, including the human rights issues, refugees, narcotic drugs and psychopathic substance, traffic in persons, absence of publication, health, international trade and development, transport and communications, navigation, economic statistics, education, cultural matters, declaration of death of missing persons, status of women, freedom of information, penal matters, commodities, maintenance obligation, law of sea, commercial arbitration, law of treaties, outer space, telecommunications, disarmament, environment, fiscal matters. In such a way, more than 100 other conventions are binding the citizens of India. But there is no follow-up of implementing that international treaty where we are participating. In certain cases, we are signing the treaty. In certain cases, we are ratifying the treaty. In certain cases, we are bringing the domestic law. But many of the treaties are not followed by the domestic law. And the departments involved in these matters are now widening every day. We can take the Department of the Ministry of Overseas Indian Affairs, Ministry of Water Resources, River Development and Ganga Rejuvenation, Ministry of Information and Broadcasting, and also the Ministry of Department of Atomic Energy, Ministry of Home Affairs, Department of Space, Ministry of Tourism, Ministry of Road Transport and Highways, Ministry of Shipping, Ministry of Defence, Ministry of Finance, Ministry of Civil Aviation, Ministry of Environment, Forest and Climate, Ministry of Commerce and Industry, Ministry of Social Justice and Empowerment, Ministry of Science and Technology, Ministry of Earth Science, Ministry of Health and Family Welfare, Ministry of Culture, and so many ministries. We have got more than 108 ministries. Every ministry is bound by the international treaties. But at the same time, we don't have separate Department of International Law in our government. Every nodal ministry is having their own advisors. For example, Finance Ministry, when they are going for bilateral relationship of investment, they are getting some advisors. They are putting for a certain period, ad hoc period, as ministry advisors. Similarly, Forest and Environment, they are having their own system of getting the international obligations and other things. For negotiation, they are seeking the help of the Ministry of External Affairs and Treaty Division. They are going. In many of the issues, the nodal ministry is only giving some feedback to the concerned Ministry of External Affairs on the treaties department, and they are going and negotiating with the different countries. When we are, I could have the personal experience of representing in many of the cases on behalf of India. When there are councils are coming, professional groups are coming, take for example World Trade Organization. If a country from USA is representing, they will have 150 councillors, professional groups who are totally involved in negotiation, how to go about it. China is having similar system. Even small country like Netherlands is having so much of councillors. But we are depending upon our own additional secretaries and joint secretaries who are getting the feedback at that time from TT's division. Therefore, this is the way we are running the government, but at the same time we want to see that we want to be a superpower, we want to be a very much a hub for international investment.
Be available.
The international law is not enforced, international law division is not there in India, and the law ministry is not holding any accountability on that part, whether this domestic law is properly followed by the nodal ministry or not. But at the same time, we are bound by the international law obligations. If we violate anything, then we are answerable to the international bodies. How many bodies are there? If you take how many bodies, United Nations itself is having many bodies to make the treaties and laws, and we are party to it. More than 120 conventions have been held in different subjects, and we are having different United Nations bodies. Take, for example, the Counter-Terrorism Committee Executive Directorate, Department of Economic Social Affairs, Food and Agricultural Organization, International Labour Organization, Office of Disarmament Affairs, Office of Coordination Humanitarian Affairs, Office of the Special Advisor on Gender Issues, Office of Special Representatives of Secretary General for Children and Armed Conflict, United Nations Commission on International Trade Law, United Nations Conference on Trade Development, United Nations Democracy Fund, United Nations Environment Programme, United Nations Educational, Scientific and Cultural Organization, United Nations Human Settlement Programme, United Nations Inter-Regional Crime and Justice Research Institute, United Nations International Research and Training Institute for Advancement of Women, United Nations Population Fund, Regional Commissions, World Health Organization, World Intellectual Property Organization, World Meteorological Organization, World Tourism Organization, Comprehensive Nuclear Treaty Ban Treaty Organization, Preparatory Commissions, International Atomic Energy Agency, Organization for Prohibition of Chemical Weapons, International Civil Aviation, International Fund for Agriculture Development, International Maritime Organization, International Telecommunications, and International Seabed Authority. Other than that, non-UN organization, just like the WTO, World Group, International Finance Corporation, Universal Postal Union, World Intellectual Property Organization, the Hague Conference of the Private International Law, Permanent Court of Arbitration, International Institute of Unification of Law, Commonwealth Secretariat, International Institute for Democracy and Electoral Assistance, Antarctic Treaty System. In such a way, we are going on having many representations, but without any concurrence of the Parliament. Parliament is not at all informed of any of the covenants, any of the treaties. Nobody is accountable. They take the provision of the Constitution of India where international treaties are binding upon the country. This authority is given to the executive, no doubt. But at that time, we thought that this is sufficient. But now, we need the accountability part. Our country is giving a lot of democratic process in every system. Now we need international law department to be created. I can even say to that extent, the rule of law, it is not domestic law alone. The rule of law of international law is now prevailing upon the citizens of India. Therefore, now the law ministry should get the next to the Prime Minister's position. We are even now following the colonial system of Home Ministry becoming the second to the Prime Minister. Nowhere it is relevant now. We have to take into consideration all the departments are now covered under the international obligations and treaties. Therefore, India is governed by the international treaties. Therefore, we have to oblige by bringing a proper accountability part from the cabinet. The cabinet is answerable for everything. They cannot say that the nodal ministry has said it like that, the external affairs ministry is said like that. Therefore, this is the way we have done it. But only when they are coming forward with a follow-up measure of the domestic law on the basis of the international treaty, then only this parliament knows this is the lacuna, this is the weakness, this is the way India has moved away from the international obligations. Therefore, sir, this is the high time to see that the Ministry of Law should be upgraded. It should have its own international division covering all the nodal ministries by consultation, and they should be in a professional way. It should not be way of hierarchy or in the way of having a person who entered in a legal services and then having a promotion to that extent for after 25 years, having the institutional memory. Now the institutional memory is overlooked by the international memory of the present status. What is happening today in the international forum, sitting in Geneva, in some other country, they are making some obligation, but our representation is very, very weak in the international conventions and also the TT making bodies. Therefore, I feel, sir, as a part of the working of the international, as a part of the Department of Law, I feel that this is the high time to make it as a separate department in the Department of Law. Similarly, sir, till now, the Ministry of Justice was with the Ministry of Home Affairs. The committee, Parliamentary Standing Committee on Law and Justice, has recommended as early as 2004, 2004-5, they made the recommendation that it should be separated from the Home Ministry. Once the appointment of judges and getting the information of their background and other things is needed through the Ministry of Home, therefore they were keeping it. That secretary could not get the appointment with the Home Minister at all. He or she cannot even tell the Home Minister, look here, 350 vacancies are there in the High Court, we have to fill up. That days are gone. Now UPA 1 has made it separated from the Ministry of Home and attached it with the Ministry of Law. Therefore, the things are now moving. The secretary is reporting the Ministry of Minister for Law. Therefore, it is coming up. But unfortunately, we are making laws. We are having the constitutional support for making the law, not only on any particular subject, but also in many of the issues of judiciary. If the House looks at the Article 124 of the Constitution of India, appointment of judges, starting from appointment of judges, even the constituting the Court of Supreme Court, increasing the number of judges, everything is within the powers of the Parliament. Very subtly, Dr. Ambedkar and the constitutional makers made it, Parliament is supreme, even though executive and judiciary are at par with the Parliament. How? We can take it the Article 124. It is the establishment of the Supreme Court. It is the appointment of the Supreme Court judges. It is the removal of the Supreme Court judges. Everything in the hands of the Parliament. Similarly, if you take Article 141, judgment binding of all the courts. There also, if you see that Article 141 says that for the procedures for the execution under Article 142, the enforcement of the decree or the judgment, the execution of the judgment of the court is by the way of legislation made in the Parliament. If you take the Article 146, the appointment of staffs alone are given to the Supreme Court of India. The appointment of judges were not given to the Supreme Court of India. Now what is happening? Boldly this government has brought a law within the fresh period of 60 days, the honeymoon days. They brought a National Judicial Appointment Commission. We appreciated it. We congratulated the government. If you delay it, then the court will give you some issues on the scam and other things. Then you will be boggled down. Since you are having a majority after 20 years, this government has to set aside the things which happened from 1993 judgment of the Supreme Court. Pre-1993 should be restored. That was the act you were brought in by National Judicial Appointment Commission. But what happens now? Even the government in a position to say, through the media we could understand, Attorney General has requested the Supreme Court to widen the bench, having an 11-member bench to decide on this, the validity of the National Judicial Appointment Commission. This is the way, sir. Can we give the powers to the judiciary to appoint themselves? Can the judges appoint themselves and brothers and sisters and youngsters, their own grandchildren to be the judges? Is it the power given to the parliament? Parliament is elected by the people. We have got a very fixed period of 5 years or 6 years according to the House. We have to be coming back with the consent of the people. The parliament has got the right only to appoint their own staffs within the secretariat. Take for example, executive. Executive cannot, the minister cannot appoint the secretary or IAS officers. They have to go through the UPSC process. That is the constitution says. Therefore, the executive is also having the restriction. Even though the executive is elected by the people as a cabinet system, we are regulated for appointment even of our own staff by the UPSC neutral body. Why not the judges? Therefore, it is high time that the government has to be very careful in dealing with the matter, and we should not be in a position to oblige it, having taken a Chief Justice of India, having an excuse, not attending according to the statutory obligation.
एक मेरा आपसे ये बड़ा इम्पोर्टेंट
I will restrict it within 3 minutes.
आज सर्वोच्च न्यायालय और कहीं न कहीं हम लोगों के बीच में टकराव की स्थिति खड़ी हो गई है। ये भी चैलेंज हो गया कि क्या पार्लियामेंट को पावर है कि नहीं है।
आप
इसमें कोई टाइम लिमिट मत करिए, क्योंकि इसको हम लोगों को कहने दीजिए। अगर इसमें आप टाइम लिमिट करेंगे, एक इतना इम्पोर्टेंट इशू है, अगर प्रस्तावक जो आप 5 मिनट में कोई इसमें 5 मिनट 4 मिनट आप क्या फॉर्मेलिटी नहीं होना चाहिए।
टाइम मैं तय नहीं करता हूँ, टाइम जो तय होता है वो चेयर करता है, बीच में करते हैं और वो करते हैं। आप लोग अगर चाहें तो 2-2 मिनट और एक्स्ट्रा दे सकता हूँ, इतना ही मेरे तो, इससे ज्यादा तो मेरे हाथ में है, मेरा हाथ। आप अभी करें।
देखिए,
आप इस मुद्दे को आप जितनी अच्छी तरह से बोल सकते हैं तो इसी पे कंसंट्रेट करें। कौन रोक रहा है आपको?
वाइस चेयरमैन,
आपको कौन रोक रहा है?
वाइस चेयरमैन साहब, इस जो हम लोग का हाउस है, इसमें बड़े सीनियर एडवोकेट्स हैं, एक सुप्रीम कोर्ट के, हाई कोर्ट के, अब डिस्ट्रिक्ट कोर्ट के, सबके हैं। अगर सबने अपना व्यू न रखा, अगर हमने इसकी,
मैं तो आपको रोकूंगा नहीं,
तो
इसके अंदर आप है ना,
रोकेंगे।
आप इसी पे कंसंट्रेट करें, पर एक ही इशू पर आप करें ना, ज्यादा दूसरी चीजों पर आप कम कर लें। कौन रोक रहा है आपको?
I will complete it within 5 minutes.
या I have, मैंने आपको घंटी बजाई है, मैंने आपको रोका नहीं है। इसका मतलब है कि I have just आगाह कर रहा हूं कि टाइम आपका हो गया है, मैंने तो रोका तो है ही नहीं। पर आप ऐसा घंटी तो बजाऊंगा अगर, तो मैं I can't just be, क्या कहते हैं, spectator here. I'm sorry.
Sir, already 2 minutes are taken away from my
घंटी
time.
बजाना आगा तो आपको करना ही पड़ेगा कि कितना टाइम आपका है, और वो तो बताना तो पड़ेगा।
जैसे नरेश,
Let's not have an argument here, please.
No
I will carry on.
argument. I mean, it's in a jest. I mean, you'll also enjoy it. You have not only, like Mr. Naresh Agrawal said, lawyers of the Supreme Court or lawyers of the High Court, a larger number of non-practicing lawyers are also here. Yeah. So they will.
I will give them all the respect also. येचुरी जी, आपको भी मैं पूरा रिस्पेक्ट करके 2 मिनट ज्यादा दूंगा।
Good.
Sir, what I want to stress finally on this issue of
please, let's not waste time, please. Let's not. आपका नंबर आएगा, मैं आपको टाइम दूंगा।
sir, regarding the
यही फर्क है कि हम देश के लिए एडवोकेसी करने आए हैं इस हाउस में।
Let's not have a debate on this, please. Let's not have a debate on this.
All are advocate.
भूपेंद्र जी, आप
Yes.
sir, regarding the judiciary,
मैं आपको खाली आगाह कर रहा हूँ, but आप
I will complete it within 5 minutes, sir. Sir, actually the judicial aspect, we are now empowered by the people's verdict. In 1993, 1991 onwards, we were having a coalition government system for the past so many years. Now we are having a mandate, full mandate. Therefore, the government should not shy about taking their own stand according to the Constitution. Within the powers of the Constitution, the Parliament is supreme, and it has got its own inside system of making the power to the Parliament to decide on the appointment of judges, on taking action on the judges, and reconstituting the judges, reconstituting the courts, establishing the courts, making the procedure for day-to-day affair also, whether making the court fee system, how to conduct the cases, everything is given in the constitution, powers were given to the parliament.
Thank you.
That is the way I want, I want to have, you gave me 5 minutes, sir, I will finish it. Thirdly, many of the judges, when they are retiring, they are making certain observations. But when they are sitting as judges also, they are making certain observations. I don't want to quote the name of the judge, but a sitting judge has quoted, government filing more cases is sign of governance deficit. Why there is so many cases are pending, more than 218 crores of cases are pending throughout India. There are many reasons, but we can take 2 reasons alone. One is, many of the cases, 70% of the cases are government, whether it is a state government or a central government, is party to the litigation. There should be a system by which the law ministry should work out, having a networking through all the councils who are appearing for the government of India to find out what is the stage of the case, why the case is delayed, whether proper affidavit is filed, whether evidence is given before the court, what is the end of the case. If the case is, the judgment is proper according to the law, then why do you prefer an appeal against it?
Thank you.
There are 6 lakh crore of rupees is locked in the tax tribunal alone. Our tax money is locked there because of appeal taken by the government. Why we have to take it? Sir, you are given 5 minutes, kindly go, look at the clock.
15 minutes is allotted to you. There are 4-5 speakers, and
Sir,
I have
actually, you have
already given
taken
you
3
5
minutes.
minutes extra, please.
But it
Boycott
is
का
not recorded, that's it.
आपका तो नंबर ही नहीं आया है.
चेयर को भी पावर है लोगों से है और हमें भी पावर चेयर से है। शिवन चेयर जो व्यवहार कर रहा है कि 1 मिनट दे दूंगा, 2 मिनट दे दूंगा, जैसे भीख मांग रहे हो।
नहीं, भीख मांगने आपने बीएससी के अंदर आप भी थे, आप बीएससी के अंदर नहीं थे क्या? आप बीएससी में नहीं थे क्या? आप बीएससी में थे?
हाँ थे।
तो उन्होंने उस टाइम क्या डिसाइड हुआ था?
3 आवर्स हुआ था।
हाँ, तो 3 आवर्स के हिसाब से तो देंगे।
पढ़ सकता है।
तो 3 आवर्स के हिसाब से तो देंगे आपको।
नहीं है, वो कोई पत्थर की लकीर नहीं है। ऐसा नहीं है बिजनेस में 3 आवर होगा तो 3 आवर चलेगा।
आप तो टाइम से तो चलेंगे। या तो आप लोग डिसाइड कर लो कि साहब अनएंडिंग चलेगा।
हाँ, कर लीजिए सदन।
हाँ, तो आप क्या कहते हैं, कर लीजिए।
कर लीजिए, प्रस्ताव करिए।
चलिए, तो आपके बीएससी में आपने क्यों कर दिया? चलिए
Sir, now you have to take 1 more minute. Sir, I want to finish.
नरेश जी आप विराजिए। नरेश जी, ये कोई समय का मांगने की बात नहीं है, आपको नाराज होने की भी कोई जरूरत नहीं है, आप विराज। नहीं तो सदन तो समय से ही चलेगा, आपके हिसाब से चलेगा नहीं। आप सोच रहे हैं कि आपके हिसाब से चलेगा, नहीं चलेगा, बिल्कुल नहीं चलेगा। चलिए
नरेश जी,
Sir, finally I would like to
नरेश जी,
make the
प्लीज
point.
सुनिए आप सुनिए,
second-
1 मिनट सुनिए आप।
इसका मतलब है कि आप जो मन में है, जो आप करना चाहेंगे आप नहीं करेंगे, पर आपको क्या करने की कहां जरूरत पड़ रही? मैं तो देखो समय के हिसाब से चलेंगे। नहीं तो इनके 4 स्पीकर हैं सतीश जी, दे हैव 4 स्पीकर्स। अगर इनको क्या कहते हैं, एक ही स्पीकर को दे दें तो अच्छा है ना। ओके सर, आप विराजिए। आई विल कंसल्ट दिस एंड प्लीज आप
उपसभापति जी 1 मिनट। उपसभापति जी, माननीय सदस्य 3 घंटे का समय लॉ एंड जस्टिस पर अलॉटेड है, लेकिन इसको बहुत से लोग इस पर बहुत ज़्यादा बोलना चाहते हैं, बहुत से महत्वपूर्ण विषय रखना चाहते हैं। मुझे लगता है कि रखना चाहिए, रखने देना चाहिए।
Sir, regarding the backlog of the cases and pending cases accruing every day, we would like to look at the issue in a different way, sir. The system of the governance is on the basis of the decision making. If the particular desk, whether it is a joint secretary or anybody who is taking a decision, if they take the responsibility and take the decision, there is no need for going to the court. If they take according to the rule of law, the cases will not go to the court. But this tendency of the bureaucracy and also the politicians is now, why we have to bother ourselves? Let us go to the court. Let them go and seek the remedy in the court. Let them decide it. Even in major cases, the accountability part is missing. I request the law ministry to to enforce it properly. Every ministry, every desk who is having the power to take the decision, they are accountable, they have to take the decision. If they are not taking the decision and there is a case is pending on the basis of they not taking the decision, then you take the action against a particular government servant who is responsible for that. If this happens, 2 crores will vanish and the cases will not be there in the courts. Now we are thinking as if the court alone is sitting for taking decisions, taking for the judgments, even for welfare activities, everything they are giving direction to the parliament also. You enact the law within the particular period. Just now the urban development minister says that the Supreme Court has directed. How can they direct the parliament to enact the law? They do the business, you do the business when there is a dispute, is coming before you. It is our business to make the law. Similarly, sir, we have to see that every person is responsible for taking action. If I am talking now, I am responsible to take a decision of putting a point. Similarly, every person has to take the decision. It is not the judges alone. Now we are multiplying with many tribunals, but none of the tribunals are having the vacancy filled up by the government. Every tribunal is lying vacant. Every tribunal judicial member is vacant. The other members are vacant. Therefore, this is the position why the backlog cases are coming. Every day you are producing the new regulatory authorities. You are producing new tribunals. You are green tribunal. It passes the law. You don't burn the wastages in a place. Then you will be fined for 5,000 rupees. Where is the executive? Where the executive is doing it? Whether the executive is enforcing the environmental law or not. Whether the municipality or the mayor is working properly or not. Therefore, it is a high time, sir, to think about it. And it is not a system to blame the court system alone, but it is a system of governance that makes the proper disposal of the matters and grievances redressal and response to the people. That is the response of the governance. With this observation, I thank you very much, sir, for
Thank you very much
for this debate.